आज हम लोग पढ़ेंगे प्रॉपर्टी राइट्स इन इंडिया।
प्रॉपर्टी राइट्स इन इंडिया। ओके
अब देखते हैं ये न्यूज़ में क्यों है। A 9-judge constitutional bench of Supreme Court delivered a landmark ruling in Property Owners Association versus State of Maharashtra, restricting the power of the state to acquire private property.
Okay.
ठीक है? The recent judgment has overruled the earlier rulings in State of Karnataka versus Ranganatha Reddy 1978 case and Sanjeev Coke Manufacturing Company versus Bharat Coking Coal Limited and ANR 1983. Both the cases had declared private properties could be considered community resources.
Okay.
This shift marks a significant development in the legal understanding of property rights in India. Evaluation of right to property. Original status. Initially, the right to property and compensation for acquisition were protected as fundamental rights under Article 19(1)(f) and 31 of the Constitution. 25th Amendment 1971 introduced Article 31C, which protected laws designed to fulfill the directive principles of state policy, specifically Article 39B and 39C, from being challenged for violating fundamental rights, including those under Article 14 and 19. Revised status of right to property. The 44th Constitutional Amendment 1978 removed the right to property from the list of fundamental rights, making it a constitutional right under Article 300A. ठीक है? Key highlights of the recent judgment Property Owners Association versus State of Maharashtra. अब recent judgment क्या आया है? Scope of Article 39B. The court emphasized that private property cannot automatically be classified as a material resource of the community. जो private property है उसको directly material resource community के लिए उसको नहीं माना जा सकता under Article 39B. It clarified that not all privately owned resources meet the conditions to be treated as such. सारी private property community की resource नहीं हो सकती. Article 39B provides that ownership and control of the material resources of the community are so distributed as best to serve the common good. ठीक है? Authority for property acquisition. Authority किसके पास है? Article 39B does not grant legislative power to the state to acquire private property. ठीक है? 39B स्टेट को ये लेजिस्लेटिव पावर नहीं देता कि वो कोई भी प्राइवेट प्रॉपर्टी को एक्वायर कर सके. ठीक है? The court clarified that it comes from the sovereign power of eminent domain and entry 42 of list 3 in the 7th schedule. 7th schedule के तहत ये sovereign power में आता है. ठीक है? और ये कोर्ट ने क्लैरिफाई किया कि स्टेट के पास ये लेजिस्लेटिव पावर नहीं है टू एक्वायर एनी प्राइवेट प्रॉपर्टी. क्राइटेरिया फॉर क्लासिफिकेशन. अब इसको क्लासीफाई कैसे किया जाए? द इंक्लूजन ऑफ प्राइवेट प्रॉपर्टी एज अ मटेरियल रिसोर्स डिपेंड on its nature, scarcity, impact on community welfare and concentration in private hands.
Okay.
Flexibility in economic policies. The court stressed that the framers of the constitution intended for economic policies to be flexible, allowing governments to adapt to changing needs rather than being tied to a fixed economic doctrine. ठीक है? In spite of being fixed in terms of economic doctrine, the policy should be flexible. ठीक है? हमेशा रिजिड नहीं होना चाहिए. वो सिचुएशन के साथ, चेंजिंग नीड्स के साथ वो अडेप्ट करना चाहिए. वैलिडिटी ऑफ आर्टिकल 31C. इसका वैलिडिटी कब तक है? द कोर्ट अनएनिमसली रूल दैट आर्टिकल 31C upheld in केशवन एंड द भारती केस इज स्टिल वैलिड. ठीक है? बैलेंसिंग पब्लिक वेलफेयर विद प्राइवेट प्रॉपर्टी राइट. प्राइवेट प्रॉपर्टी राइट्स के साथ पब्लिक का वेलफेयर कैसे जुड़ा हुआ है उसको बैलेंस करना है. द कोर्ट बैलेंस पब्लिक वेलफेयर विद प्राइवेट प्रॉपर्टी rights, ensuring government actions align with constitutional principles like equality and right to property, Article 300A. It is also applied the public trust doctrine, mandating responsible resource management for the public good. Limits of eminent domain. Limits क्या क्या हैं? The court questioned the broad application of doctrine of eminent domain in land acquisition. The court clarified that not all privately owned resources qualify as material resources of the community that can be appropriated for public good.
Okay.
वे doctrine of eminent domain क्या है? It provides that government can acquire private property for public use. ठीक है, इसमें बोला गया है कि जो गवर्नमेंट है वो प्राइवेट प्रॉपर्टी
Okay.
पब्लिक यूज के लिए यूज कर सकती है.
Okay.
Balancing societal welfare with property rights. This power is exercised by all level of government, but fair compensation must be provided to the owner. जो भी प्राइवेट प्रॉपर्टी का ओनर है उसको फेयर कंपनसेशन मिलना चाहिए. एलिमेंट्स ऑफ डॉक्ट्राइन ऑफ एमिनेंट डोमेन. इसका एलिमेंट्स क्या क्या है? पहला है पब्लिक यूज, जस्ट कंपनसेशन, ड्यू प्रोसेस, गवर्नमेंट अथॉरिटी. ठीक है. पब्लिक यूज क्या है? गवर्नमेंट कैन एक्वायर प्राइवेट प्रॉपर्टी फॉर पब्लिक पर्पस लाइक इंफ्रास्ट्रक्चर, बट ओनली इफ देयर अ लेजिटिमेट नीड एंड नो अल्टरनेटिव. जब कोई अल्टरनेटिव ही नहीं है, अगर वो कोई इंफ्रास्ट्रक्चर के बीच में आ रहा है तो वो एक्वायर कर सकती है. जस्ट कंपनसेशन. व्हेन प्रॉपर्टी इज एक्वायर्ड द गवर्नमेंट मस्ट प्रोवाइड फेयर कंपनसेशन टू द ओनर बेस्ड ऑन द मार्केट वैल्यू एट द टाइम ऑफ एक्विजिशन. ठीक है, उस टाइम पे जो भी रेट चल रहा हो, प्राइस चल रहा हो, उसका फेयर कंपनसेशन मिलना चाहिए. Due process requires due process, meaning property owners must be notified in advance and given a chance to contest the acquisition or negotiate compensation. ठीक है. Government authority. It can only be exercised by the government or authorized public agencies with legal authority to take property for public use. It is typically regulated by legislation in most jurisdiction worldwide. ठीक है. Important case laws. केस लॉज कौन कौन से हैं? In Sudarshan Charitable Trust versus Government of Tamil Nadu 2018 case, the Supreme Court clarified that eminent domain is tied to the state's sovereignty. The state can acquire private property for public interest provided fair compensation is given. This power does not violate person's rights to livelihood or dignity. ठीक है, ये किसी की livelihood या फिर dignity पे बात नहीं आनी चाहिए. Public Trust Doctrine, ये क्या है? It helps protect the environment by ensuring the responsible management of natural resources. By invoking this doctrine, we can safeguard these resources and promote the protection of earth. It was recognized as a part of Article 21 in the landmark cases. Majra Singh versus Indian Oil Corporation and MI Builders versus Radley Shyam Sahu. ठीक है. State as trustee. Under the public trust doctrine, the state acts as a trustee, managing natural resources for the public's benefit, ensures that resources are used responsibly and not depleted or damaged. ठीक है. पब्लिक ट्रस्ट डॉक्ट्राइन में स्टेट एक ट्रस्टी की तरह काम करता है जो इंश्योर करता है कि किसी भी प्राइवेट प्रॉपर्टी जो है उसके वजह से कोई नेचर या इन्वायरमेंट में या फिर रिसोर्सेज में कोई डिप्लीट या डैमेज ना हो. T.N. Godavarman versus Union of India. The Supreme Court affirmed that the state as a trustee must ensure natural resources as used sustainably for public good. Citizens and as beneficiaries. The citizens are the beneficiaries of the trust, using resources sustainably for their benefit and future generation. इसके implications क्या क्या हैं? Legislative and policy impact. The ruling may influence future property acquisition laws, land reforms, and social welfare programs, promoting fairness and transparency. Economic reforms. The decision signals a shift to a more market-oriented economy by limiting the state's power to acquire property, supporting private investment while ensuring social justice. ठीक है, ये दोनों को बैलेंस करके चलने वाला. Political debates. Political parties may adjust their stances on land reforms and property rights, while the ruling could shape social welfare programs, especially land redistribution for the underprivileged. Constitutional scrutiny. The judgment reinforces the judiciary's role in scrutinizing government actions on private property, ensuring laws align with the constitutional rights, including equality and property. ठीक है.